trademark registration process in the UK. What is a trademark? This is not a definition from the Act, but mainly a more sort of what I would call as a commercial definition. This definition has actually been given by the SITMA, who's the Chartered Institute of Trademark Attorneys. They're a regulatory body who regulate trademark attorneys in the UK and in the EU as well, if you are qualified in the EU. A trademark is a badge by which customers find your products or services in the marketplace. The owner of a trademark has exclusive use of that sign. Once in use, your trading reputation and goodwill will be attached to your business, making your trademark some of your most valuable assets. In effect, it is a symbol of trust. In the UK, a number of types of trademarks can be registered. To name a few, it could be a word mark, logo, shape, a position, pattern, color. It can be a single color. It could be a color combination, a sound, motion, multimedia, hologram. There are obviously more that keeps getting added to the list, and this is of course treated on a case-to-case basis. Generally in India and in the UK, prior to applying for a trademark registration, we always conduct a search. Now, this somehow seems to be a step that a lot of people or lawyers and clients want to skip to avoid the costs that are involved in conducting a search. However, personally and professionally, we would always recommend that a search has to be carried out. And if an applicant so wishes to file the application themselves, they would still have to carry out a search. And some of the reasons are very simple and straightforward. It is to make sure that you're not inadvertently infringing anybody's trademark, to see what is out there. You want to avoid your application from being opposed. Also, there are higher chances of success for the application progressing to registration. And generally, it is regarded as a good and sound legal advice that you would provide to your clients. Very quickly, again, like India, UK has a classification system under which you file your trademark applications. We have 45 classes. Class number 1 to 34 are specifically related to goods, and class numbers 35 to 45 are specifically related to services. I touched on this in the search topic about the MADRID Protocol, which is basically what we would call in general terms as international application. So the the UK is a member of the MADRID Protocol. India wasn't a member while I worked in India for a number of years. However, I think they became part of the MADRID Protocol somewhere post 2011. And now it basically means that you can file an international application at the Indian IPO and then designate the number of countries who are members to the MADRID Protocol. In the same way, UK has been a member of the MADRID Protocol for a number of years now. So they are an office, they have a department which deals specifically with only the WIPO applications. And of course, they charge a very minimum fee to process those applications, and it's just £40. But obviously, when you designate the countries, there will be a bigger fee that you have to pay. But this is just if anybody is curious to know what is the sort of handling fee. I can't remember what the handling fee at the Indian IPO is, but again, the handling fees will usually be quite subsidized because they are just acting as a postmaster to send the application they forward it to WIPO basically. So they probably charge some administrative fees at the end of the day. Also, something to bear in mind with the UK trademark system is UK is a member of the Paris Convention. So I spoke about this in the previous slide, again under searches, where we touched on priority claim. So let me, for anybody who doesn't know what this is, the Paris Convention is an international treaty which has a number of member countries who have signed up to this treaty. And one of the main, it has a number of aspects to it, but the most important one and the most relevant one to this webinar is that if you file a UK trademark application on today, 12th of April 2021, India is part of the Paris Convention. Within 6 months from the date of filing your UK application, you can then file your India trademark application, and you can claim the 12th of April 2021 as your filing date, because this is what the Paris Convention affords to the member states and applicants who belong to these member states. You get what we call a 6 months convention, priority convention. So in a way, effectively, you are filing a trademark application in the UK, and then let's say after 3 months you file it in India, but you are claiming 12th of April 2021 as your filing date, even for your India trademark application. Now, one may think, why is this so convoluted? There is a great advantage on this, because the trademark, both in UK and India, it is a simply first come, first serve basis in terms of application and registration. So if you were to file, if you were to take your UK application date, and let's assume somebody files a slightly or phonetically similar mark in India on the 19th of April 2021, your application supersedes them. Therefore, they cannot object to your application simply on that basis. So a lot of clients actually make use of the 6 months, and we advise strongly to clients who file a trademark application in the UK to consider this aspect. And if they plan to sell their product or launch their product in a variety of markets, we do strongly advise them to proceed and file in those respective jurisdictions by claiming that 6 months priority. So this is again something that the UK trademark system affords to applicants, is something to bear in mind when you are advising clients on the UK trademark process. And also another thing to remember with the priority claim is your first application, which is in this instance, the UK trademark application, need not have registered. It can still remain pending. And in fact, in India, when I did work in India, one of the things is the timeline from application to registration is quite prolonged. I think the earliest I've seen an application register, at least in the time that I worked, there was around 24 months, that is close to 2 years. So you don't have to wait for your application to go through and actually get a registration certificate. The moment you apply, that 6 month priority clock will start ticking, and then you proceed and you go ahead and you file in all the member states, if you so wish, who are members of the Paris Convention. So that is another thing to bear in mind. So with the UK trademark, many people ask me this: what is the kind of timelines involved? I think because of Brexit, there is significant delay now in terms of processing the application up to the stage of examination. But prior to, I would say, beginning of last year, I have seen an application being filed, and it has probably registered within 4 months. Actually, that's the fastest I've seen an application register in the UK. I'm not saying that it is always the case, but that is quite possible in the UK. However, because of Brexit and the UK IPO being involved quite considerably, with handling a number of things due to the Brexit situation, at this point in time, we are seeing that it takes around 12 weeks for an examination report to be issued. Again, of course, quite similar in terms of the process of what a trademark application will go through up to registration, very similar to India and UK. If the examination report, if there are no objections raised by the examiner, the application will proceed to publication. However, if there are objections raised by the examiner, we have to deal with that. And I will talk about some of the grounds that the examiners will raise and what they can raise in the next couple of slides. We will touch on that topic. However, if we assume that the examiner hasn't raised any objections, the application will get published. You have 2 months to oppose the application. Now, in the UK, again, a slightly different process to India. The 2 months opposition period can be extended by 1 month if one of the earlier trademark applicant or a third party will file a notice of threatened opposition. This is done by Form TM7A. There's no fee for this. And what it basically does is the moment you file the threatened notice of opposition, the 2 months opposition period gets extended by a month. So in total, we would have 3 months from the date of publication. If we assume that nobody opposes your application, then the application hasn't been opposed. It will go immediately to registration. A registration certificate will be issued. Up until we went into a major lockdown last year, we were actually getting physical trademark certificates from the UK IPO. However, there was significant delay because of the pandemic, of course, and now they have stopped that process completely. They do not issue hard copy certificates. It is simply a soft copy certificate. In fact, the European Trademark Office stopped issuing hard copy certificates many, many years ago. So I think they are following that. It is quite simple and straightforward. You get it in an email, and it is it has the same value as that of a hard copy. I think the pandemic obviously put things in perspective for the UK IPO, and they decided and they've changed their practice completely now. So the registration certificate is only an e-registration certificate, if we can call it that name. So generally, again, as I said, a smooth UK trademark application with no objections from the examiner, no oppositions by third parties. We are looking at a 4-month. So from application time date up to the issuing of registration certificate, which is quite quick and fast in my opinion. But sometimes things can get quite delayed depending on each application. Again, this is a case by case, but it is something good to know. So in effect, you could get a trademark registration certificate in the UK most likely in 6 months from date of application, which is quite quick.